Hi y'all, if you can hear me, we're gonna get going in just a minute or two. Just letting folks in, and we've had a very strong interest in this webinar, so we're really excited to dive into the crazy world that we've been presented with in the last week. We have an army of lawyers that will be speaking about anything from business implications to paths for federal change, state change, litigation issues, and sort of everything in between. So we're really going to take a deep dive at the firm. We've been fortunate to be at the table for a lot of these discussions as we've been trying to chart paths forward on this. So in about a minute or two, we're going to dive right in. And maybe Sean, could you mute your microphone? Cool. Hopefully that's better with the echo. Let's see, we'll give it about 30 more seconds and then we're going to dive on in. But much to discuss. I'm assuming we're better on the echo. No echoes here. Wonderful. Okay, well, welcome y'all. Brian Vicente with the firm Vicente LLP. We have been working on cannabis issues for a long time, several decades, and we are here to talk deeply about this sort of massive federal change that came down last week. It's been a hell of a week since then, but we have an army of attorneys that will be explaining issues related to business, policy, state, federal, etc. As a quick recap, in 2018, we had the federal government sort of open this farm bill loophole. We since then had a $28 billion industry that came out of that and has really thrived in the past, a number of years on this, and really has opened up access to cannabis for millions of Americans, whether that's, soccer moms in Tennessee or patients in Texas or where have you. There were many good actors that were producing hemp products, and there are frankly some not wonderful actors. But instead of acting to regulate those bad actors, what Congress did last week was really use a sledgehammer and just smash down this industry, creating this sort of de facto or essentially a ban on any product over zero point 0.4 milligrams of THC. Now, we do have 1 year to address that, and we're going to talk about what is 0.4, how does this affect work in progress, et cetera. We're going to go deep on all of these issues, but we do have sort of a year to figure out business plans around this, to figure out political strategies around this. And I do know that this will be a catalyst for change. You have millions of people in prohibition states and otherwise that really had access to regulated cannabis, via hemp for the first time ever. I don't think in a year when those products become illegal, should nothing change, that they will happily go back to consuming alcohol or opiates for pain or whatever. I think once you've shown folks that cannabis is medicine or cannabis can be used for recreational purposes in a sensible fashion, they want access to it. So what will that lead to, right? Will that be folks pushing for hemp law changes in their state? Will that be folks saying, I'm going to go to regulated dispensaries when previously I just got hemp online? Will that lead to individuals and trade associations really pushing back hard at the federal level to say, hey, we want these products here, or we simply want regulated cannabis in our state, no matter how that looks, because it's a benefit. So these are some of the questions ahead of us, and we're going to dive into these today. I'm going to turn things over to my partner, Sean, in a second. We are going to walk through state considerations. We're going to walk through 280E and corporate considerations. We're going to walk through litigation strategies around this hemp ban. We'll talk through both state and federal policy paths to address this. So with that, I'm going to turn things over to the head of our hemp department, my partner, Sean Hauser.
Thank you, Brian, and thanks everyone for joining. This is an awesome group of folks here. As Brian noted, we have a new federal appropriations language, which the hemp language passed is the package to fund the government. That is, essentially rewritten the rules for the hemp landscape and also set the table for, the future of state and cannabis legislation. And I think with challenge here also comes opportunity, as Brian noted. So what is the Agricultural Rural Development, Food and Drug Administration and Related Agency Appropriations Act, we'll call it the budget bill, essentially rewrites the federal definition of hemp that we've had since 2018 in the Farm Bill to make a highly restrictive definition, which is limited to 0.4 milligrams total THC per container. And, what effectively is anticipated to wipe out much of the commercial hemp industry as it exists today, which is estimated to be a $28.4 million industry, unless we're able to, again, amend the language here and hopefully in the long term, develop a sensible regulatory framework for cannabinoids. Importantly, and the good news out of this language is the changes in the law do not take effect for 1 year, so November 12, 2026. And this window is vital, one for opportunities, which we'll get into in a bit, as to amend the federal law to ensure a legal pathway for hemp cannabinoid products. But two, this allows for mitigation and business planning and operational considerations, which we'll also get into in detail. A little bit more about the federal law. So the THC definition in the federal definition of hemp is now changing from 0.3% THC on a dry weight basis to a significantly narrower and highly restrictive definition, which is 0.3% total THC, meaning the THC calculation will expressly include THCA and any other cannabinoids that the HHS secretary determines to have similar effects as THC. So this would include delta-8 THC and a number of other cannabinoids. And then second, a final consumer product sold at retail may not contain more than 0.4 milligrams combined total THC per container. So this is, effectively prohibits most commercial products on the market, including a number of, full spectrum CBD and other minor cannabinoid products, even those that have a trace amount of THC may not meet the standard or may not be able to be produced practically given the new standards on intermediate material. Container is defined as the innermost wrapping, packaging, or vessel in direct contact with the final product and does not include bulk packaging. So it's important to remember when you're looking at this definition, what is a container? How does that work with your product? But note that it's container, not serving. So really the language effectively in a year is going to criminalize, put back into the Controlled Substances Act, intoxicating and even some non-intoxicating products that exceed the total THC limit, and final products that contain more than the 0.4 milligrams total THC, and any products that contain synthetic or converted cannabinoids. The new definition expressly excludes from legal hemp products and also intermediate material, work in progress hemp, that contains synthetic or manufactured cannabinoids. So this includes, any cannabinoid synthesized outside of the plant. And any of these products will, a year from today, revert back to illegal Schedule I status under the CSA. The language on synthetic and manufactured cannabinoids is broad, and also includes even naturally occurring cannabinoids that were in the relevant product synthesized or manufactured outside the plant. So that will be notable, including for intermediate materials. It also notably redefines the legal nature of seeds, which is now directly tied to the compliance of the parent plant, meaning if it comes from a marijuana plant exceeding 0.3% total THC, i.e. marijuana genetics, those are now marijuana. The law is notably silent on tissue cultures and clones that test below 0.3% total THC, which is a significant portion of genetics. As we've seen in other federal hemp bills, this bill mandates the FDA to take important action. The FDA is mandated to issue clarifying guidance within 90 days. So that would be February 2026 to further define critical terms like container and to list all psychoactive cannabinoids counted towards the new milligram limit. The FDA's determination of cannabinoids with similar effects to THC, which is part of their mandate, is critical because which substances those are will contribute to what counts in the 0.4 milligram limit and the combined total THC per container for final products. And the FDA is tasked with determining which cannabinoids those are. So failure by the FDA to meet this deadline, which is very possible, given FDA's history with these deadlines, and unless we have more earmarked federal funding and resources for this, this could leave us without some necessary regulatory clarity. And FDA in the past, as we know, has been very clear that they need Congress to give them more authorities and to develop a new structure governing cannabinoids. So ensuring the FDA does their job here is critical. And so as of the delayed effective date, November 12, 2026, products exceeding that 0.4 milligram limit will cease to be federally defined as hemp, and then we'll revert back to the Schedule 1 marijuana. So this puts their enforcement back under the Controlled Substances Act, back under the CSA. And obviously that will be the core piece to address in federal reform efforts, and the key consideration for states to consider, as many states have controlled substances laws that now legalize marijuana or have legal frameworks for hemp. So I'll turn it over to my colleague Neil to go through the state considerations in more detail.
Thanks, Sean. So a lot of what we've been kind of wrestling with and working through is, how does this federal change to the definition of hemp, specifically, like Sean mentioned, excluding consumable hemp products with more than 0.4 milligrams of THC in them, how does this federal change impact state controlled substances laws? Once the 365 days expire, and if there is no change, these products will be back into Schedule 1 at the federal level. So this will immediately create a legal conflict in nearly every state where hemp products are currently legal, specifically those ones that have robust hemp regulatory programs. And again, the central question is, how will state laws react to this federal schedule change? The response here depends entirely on the regulatory mechanisms each state has established for adopting or removing or rescheduling substances when a federal schedule change occurs. And there's broadly three groups of states. States that the first is states with trigger provisions that require automatic adoption unless interested parties object. The second group are states that require legislative or regulatory action to reschedule. And the third is states that have discretion to schedule substances in accordance with federal law. And the largest category of states is that first category. There are about 27 states that have that automatically update their controlled substances schedules to match the federal CSA. So on day 366, when consumable hemp products with more than 0.4 milligrams of THC are no longer included in the definition of hemp and moved back into the definition of marijuana, in these 27 states, the state scheduling procedure is triggered automatically, and the state must control the substance in accord with federal law unless the state regulatory body that controls the state CSA and or an interested party objects. In a lot of these states, interested party is not defined, while the regulatory body that controls and oversees the CSA generally is. So if there is an objection, the controlling authority must comply with state notice and hearing provisions. And this typically during this notice and comment rulemaking, the state authority generally considers the same statutory factors that the FDA and DEA consider when making the original federal decision, again, here to reschedule consumable products with more than 0.4 milligrams of THC back into the Controlled Substances Act. Specifically for hemp, some of the states in this category include states like Alabama, Iowa, Kentucky, Louisiana, Oregon, Rhode Island, Tennessee, and Texas. So these are states that have, again, robust and well-established hemp programs, some newer than others, that are going to be forced to confront how to handle hemp if day 366 occurs and there's no change to federal law here. The second group of states are states that are states where administrative review is required and rulemaking process is required. So action by the state's controlling authority or the state legislator is required before the federal change is adopted. And it kind of provides a buffer because in these groups of states, there's 13 of them. There is not an automatic trigger. So on day 366, it doesn't automatically trigger a process. The state just has to act. So there's time to discuss with the legislator, with the regulator on process forward to really create and devise a strategy on whether the state wants to have a intrastate hemp program or not. States in this category, again, those that have that regulate hemp via some sort of robust regulation or scheme include Colorado, Connecticut, New York, and Utah. Again, in all of these states, as well as the ones in the first category, they have permissive programs that allow well over that 0.4 milligram per container threshold. And the last category of states include 10 states where these states have discretion to schedule, again, keyword here, discretion to schedule or reschedule rather in accordance with federal law. And the states in this group include states like Florida, Georgia, Minnesota, Virginia, and West Virginia. The controlling authority in these states has discretion to schedule substances in accordance with federal law. But again, like the second category, regulatory or legislative action is still required. And these states are not automatically bound by federal change. Instead, they must actively engage in a rulemaking process. And when making this determination to reschedule in accordance with federal law or not, generally state law provides that they must take into consideration the federal change, and again, generally consider the same statutory factors used by FDA in making and DEA in making its determination to add or remove a substance from the state's controlled substances list. One thing that I want to highlight that I think is a little bit lost on the industry and folks who advise clients in the hemp space is that this is really the first time in history the federal government has expressly sanctioned and approved any amount of THC in a consumable hemp product. That's huge progress. Yes, it is a very low amount, but I think it can't be lost throughout this process that this really opens the door for much deeper discussion for federal policy change. Prior to last week, no THC was expressly allowed in consumable products. And here we finally have that at the federal level. So again, that point should not be lost throughout these next several months as the industry is certainly trying to put together an action plan, because that is a huge step forward. I digress. So it's kind of a review. I know I was giving a lot of information, but as the industry and state legislatures and state regulators think about the path forward over the next several months, when we think about those states with the automatic trigger provisions, Again, the bigger hemp states that have automatic trigger provisions include Alabama, Indiana, Iowa, Kentucky, Louisiana, Tennessee, Texas, and so on. There's a short window to object here and force or create a discussion on that includes an administrative review before the automatic Schedule 1 adoption takes place. So it's going to be important to get on the same page as regulators, as legislatures in those states much earlier. And when we think about practically, which is what my colleague Cassia is going to get into in just a moment, but when we think practically about how states deal with what could become illegal, federally illegal controlled substances, we think about the state marijuana programs, right? At the end of the day, a product with 4 milligram, in 366 days, a product with 5 milligrams of hemp-derived THC will not be included in the definition of hemp and will be a Schedule 1 controlled substance at the federal level. So if a state continues and wants to continue having a hemp program, they will need to kind of wrestle with those challenges, likely meaning intrastate only, no interstate commerce, no direct-to-consumer shipping, which we know is a large component of the industry currently, in a whole host of other factors. So I think, Cassia, this is a good point to turn it over to you to discuss some of those practical implications of what this means.
Thanks, Neil. I'm going to talk a little bit about supply chain contracts, and then my colleague Charlie is going to talk a little bit more about business implications. I'm going to keep this pretty brief because I think the focus at this juncture where we're at today is largely on advocacy and policy. What can we do as an industry and as people work in this space to try to prevent an outcome with the total ban in 350 whatever days we have left with the ticking clock. But it's important to have a good defense as part of your offense strategy here. It's a very unique situation in that both sides, or however many sides of every contract, will be impacted by federal illegality should it go through. So you have the entire supply chain affected, as well as investors, groups loaning money to businesses. Everybody's going to be looking at the next 12 months and kind of breaking it into chunks based on supply chain considerations and when is there a realistic opportunity to realize federal reform efforts as different efforts coalesce around those options. In terms of what we can do today with contracts, I think it's important not to panic and perhaps plan for the worst, but to analyze sort of the entire state of contractual relationships between parties in the supply chain, focus on outreach and legislative advocacy, of course, and ensuring that there's an industry to come so that the clock never runs out, essentially, at least for some product types. But analyzing supply chain contracts and relationships to assess possible outcomes and having proactive conversations and discussions with participants in that supply chain to consider how things could play out over these next, let's say, like 3 months through the end of January and chunks after that. The lifespan of these products is, up to a year or more. So, how are products in inventory going to be treated? What are the state of our contractual commitments and relationships as a whole? Most commercial or many commercial contracts in the space do have change in law provisions that allow for reformation and or early termination that are triggered by changes in federal law. However, they typically don't spell out every step that's going to happen and how risk would be allocated. A lot of distribution contracts, for example, have buyback clauses. But we're talking about a much larger universe of contracts than just distribution when you're looking at the entire supply chain, and obviously stress to one segment of a supply chain from folks who are familiar with operating in the cannabis industry for years can impact the entire flow of funds and have much larger implications throughout the supply chain. Here you have everything from whip to retail being impacted by the prospective changes as they go through. So everybody's going to be, I think, incentivized to work together and try to have, real discussions about what could happen, at different points along this time frame, to the extent that we don't have meaningful change. People need to be looking at purchase order agreements as well. To the extent that you don't have robust contracts in place with your supply chain partners, if it's just sort of a terms and conditions purchase agreement, with sort of the small little language on the back, it may not have a change in law or termination right, but there's underlying contract law doctrines for things like frustration of purpose and impossibility that may trigger a termination right by, in this case, either party, since everybody's going to be kind of in the same boat. A big focus is going to be risk allocation, obviously, and that's why rather than waiting until the end and not acknowledging the potential for things to go sideways if we're not able to achieve meaningful reform, looking at provisions like delivery schedules and inventory management, planning with our partners, for how these fungible products are going to be treated. At the same time, monitoring state law changes as we go through this transition period is going to be important. States without, robust policies, monitoring for risk of increased enforcement. How does the contract allocate that risk and responsibility? Are strong for states with strong regulatory programs in place? Are they proactively working, on implement regulation? To Neil's points about the trigger states, et cetera. On the more commercial side, looking at buyback terms, termination penalties, who's responsible for unsold inventory should the worst arise. Trying to mitigate cash flow issues, from all sides of the supply chain. Compliance reps in the contracts will most likely have to be changed or revised, even if we are able to achieve some federal reform. Most hemp contracts that we work on at least rep to compliance with federal law, with potentially a carve out for FDA's interpretation of FFDCA for consumable products. That may need to be altered depending on the ultimate outcome of the federal discussions. And then we need to look at things like indemnification clauses, who's allocated expenses and risks to the extent that there are outside issues with the contracts of the products, and risk for increased product liability, considerations. And again, I think a lot of these will become more clear as we see how the pathway unfolds over the next 3 months, 6 months, et cetera. But kind of looking at our message today is to proactively think through and start having discussions with your supply chain partners to avoid a situation where, we're further down the road and there's lack of capital and heightened sense of risk and issues with products that are expensive being asked to be paid for and taken back, etc. That the thinking through these things, not planning for the worst, but just engaging with people and understanding your positioning is important today. And then finally, alternative solutions to bringing products to market. We'll talk a little bit about throughout this session about the intrastate prospective markets that may come out of this and ways to, that obviously pressure supply chain considerations significantly, as anybody who comes from cannabis knows. But there are pathways there that, could be considered as alternatives. And I think that's probably a good segue to turn it over to Charlie Alvacetti, who leads our corporate group, to chat a little bit more about some of those commercial implications.
Thanks, Cass. Yeah, so talking a little bit about corporate implications here for the next 5 minutes. It's this, I'm sort of just kind of issue raising at this point because the specific answers are going to really vary based on the specific company. But obviously the big thing to realize here is that once once the definition of hemp officially changes, if you're selling a Schedule 1 substance, you're selling cannabis, you're now going to be subject to 280E, which is the section of the tax code that says if you're trafficking a Schedule 1 or Schedule 2 substance, you can't make ordinary business deductions. Supreme Court has decided that you can deduct cost of goods sold. But in effect, anyone selling cannabis in America today is paying a far higher marginal tax rate than the average business. There are approaches to mitigate that tax burden. There's 471C. There's the approach people are taking right now, which is as if 280E didn't apply, which is, deserves sort of a full webinar focused to that specifically. But yeah, bear in mind that 280E will apply to you if you're selling a Schedule 1 substance, which most hemp products will be once the year process runs out. Now, one interesting aspect of 280E is you can have a business that has multiple lines of trades of business, some of which are subject to 280E and some which are not. This has been litigated. I mean, tax courts have certainly shut down some cannabis companies that have tried to say, hey, we've got 2 lines of business, and they say it's really just 1 line of business. But if you've got multiple lines of business here, you may want to consider sort of having it broken out different entities. Part of this is just to maintain books and records, right? To make it clear that this is subject to 280E, this is not subject to 280E. So for example, if you were to say, okay, we're going to continue to sell our hemp products, which are going to be sort of, low dose, 0.4 milligrams, right? But we also want to sell, high THC products, which we're going to do through, through the licensed cannabis, state licensed cannabis system. I would probably keep those 2 separate businesses. So that's 280, which is something important to think about. One other question is, right, structuring entrance into the licensed cannabis market. So, in the hemp world, right, a lot of stuff is done through co-packers. The co-packers sort of tend to, they just have one production facility and they ship nationally. You can't really do that with cannabis. Cannabis is really a state-by-state game, and you sort of have to find a co-packer in each state in which you want to have production. And sort of prior to the emergence of hemp, the way brands went national in cannabis is, they would have relationships in each of their different states, and they would have licensing agreements in each of these different states and produce the product. And again, this is a pretty complicated subject that deserves sort of its own webinar. But, that's something, and looking at those IP licensing agreements, you want to be careful about how they're structured, because whether or not you're subject to 280E in an IP licensing arrangement can depend on the facts and circumstances of the contract, how it's worded, how payments made. And you want to make sure your accountant is comfortable, if you want to file taxes as if 280 doesn't apply, that your white labeling contracts sort of don't make the person who's preparing your taxes uncomfortable because they have to sign off on the taxes. This is, with a lot of this stuff with cannabis and tax, it's a question of, there's a lot of gray area here. And of course, there's a question of, what happens on an audit. But these are things you should be thinking about. And the last thing I'll touch on briefly here is, once the clock runs out, right, and you want to continue being in sort of the high THC game, you have to sort of think about, how do I structure these high THC operations? And how you structure that may depend, or will depend, I think, on your comfort level and what your position is. So for example, if you're publicly traded, NASDAQ, New York Stock Exchange is not going to let someone listed on the exchange hold a cannabis license. However, people on both those exchanges do have sort of convertible interests in cannabis businesses. So, you saw this happen with the Canadians expanding into the US a few years ago, where people would have these arrangements where they had an ability to sort of buy out cannabis operations upon a change in federal law. So I think, a hemp beverage company could potentially do that today, where, you sell, you could sell low THC beverages legally through the continuing hemp market, and then have operations on the cannabis side of things. That's with some sort of structure, convertible share structure or something like that. Some people might be comfortable with being off sides of the Controlled Substances Act. Some people may not because, again, perhaps you have a federal license, you have a license with a TTB that you're concerned about. I think you can structure these things such that you could tell them that you're not in violation of federal law. That's what people have done on these public exchanges. So, I don't think, if the way I also look at it is, some aspects of the business may have to go off balance sheet for a period of time until the law changes, in which case they can be reabsorbed on the balance sheet. But, so there are ways to structure around this to keep yourself, in the game and continuing selling, whatever ITHC products you're currently selling, in the hemp market. And with that, and I guess one final point before I turn it over to Tim here, which is, you want to look at your commercial arrangements because you may have a contract that you may no longer be able to contractually fulfill at a certain point because of the change in law. And so you want to think about, hey, have I made a promise that I can't deliver on? Is this potentially giving me any kind of, exposure? And with that, I'll turn it over to Tim to talk about litigation.
Thanks, Charlie. And that's a good segue into talking about some of the business litigation that we expect to see arise out of this change. But before I do, I think I'll just very briefly address the elephant in the room, which is potential legal challenges to this change in law. So because this is federal legislation we're talking about, many of the claims we're typically seeing brought to challenge state legislation or regulations simply aren't available here. Now we need to dig into them further, but we're investigating creative claims as well as novel approaches to traditional claims like those brought under the Fifth Amendment's taking clause, equal protection and due process clause arguments, potential antitrust claims, among others. And as we do, we're paying particular attention to the relief available to the prevailing party, which is, can make a big difference between, a kind of a pointless exercise and one that actually could bear fruit. And then also the overall impact that these arguments, as they're presented, may have on the industry's positioning in terms of lobbying and other efforts. So turning to the business litigation piece of this, so we're preparing clients to, avoid and where necessary address the types of disputes that may arise over the next year due to this impending ban. And I'm going to give, 4 examples here, which are just a few among many that we typically address here. I mean, one, that Cassia and others have set up is the typical breach of contract claim. There's going to be a lot more potential for these claims to arise in this atmosphere. I think, as Charlie and others have said, everyone should be paying very close attention to the clear wording of their agreements and getting the advice they need to understand those. I'll give you an example. Profit sharing agreements. We've seen them give rise to claims based on, a profit sharing partner starts to become suspicious. They haven't been getting P&Ls. And that's because the company may not have been very profitable to date, or for some other reason. It just wasn't the custom. But in this atmosphere, it can breed some suspicion, which then, tied with lack of communication, can quickly let things spiral out of control. And so, if you're, to avoid these situations, as everyone is, I think, hammering home today, frequent and thorough communication with your contractual partners, maintain the obligations under the agreement, especially those to disclose information, even if it seems redundant or unnecessary or contrary to what the custom of this agreement has been to date. I think all of that can help avoid some of this to the extent it is avoidable. Another big area of dispute is shareholder and partnership disputes. These disputes arise at many different times, but as you're winding up a business, selling assets, old grudges can emerge. There's a lot of different triggers to these types of claims that can arise when there's such a legal sea change like this. As an example, we've seen, investors demand the full return of their investment, and that is that is a minefield in some respects, especially in a situation like this where you may be winding up or you may be, facing that potential. Being extremely careful about, what you're giving one investor versus other investors, making sure you have buy-in from everyone that you need buy-in from, and you're going through the process, all the corporate formalities in a way that is, bulletproof is really important. You really got to also differentiate between unreasonable demands and when there are demands that really need to be, investigated and then negotiated or mediated toward a resolution as necessary. Third area is employment disputes. Layoffs, often result, or sometimes result, I should say, in EEOC type claims under state law, such as wrongful termination, discrimination, harassment. It's really important to involve counsel before laying off employees. It can make all the difference between a administrative and then a pure litigation over some of these terminations that really at the end of the day are going to cost you more than the employee cost you. So it's really important to get counsel involved as early as possible. And then the fourth one I'm going to mention is real estate disputes. We're all familiar with these. They typically arise from inability to pay rent. But, in a situation like this where leases may be broken, people may be leaving behind premises. We've seen clients who, are property owners who have dealt with property being left in, terrible condition. If a business is being wound up and there are personal guarantees involved, it's important to keep in mind who you're leaving to deal with these problems once the company's gone. And so, again, like with everything else we're saying here, work closely with your landlord, work closely with your tenants, make sure there are no surprises, make sure everyone's in agreement at every stage of the process as you're leaving a property or entering a new one. So in general, avoiding or resolving these disputes in a timely and cost-effective manner can make all the difference. Stay in close contact with co-owners of your businesses, investors, supply chain partners to avoid surprises, nip them in the bud. When disputes are not resolved between the parties themselves, involve counsel. When counsel can't, easily negotiate resolutions for you, we love to mediate. We work with some extremely talented, industry knowledgeable mediators who can really bridge the gap between parties' positions in a very cost-effective way, especially compared to arbitration or litigation. Always keep in mind that some companies will be effectively judgment-proof. Okay, there's going to be a lot of situations here potentially where there are going to be parties that you can litigate with a rock-solid attorney's fees clause, and you may not collect a dime on that. And I always tell clients, getting your judgment is half of the way there. It's not all the way there. Collecting the judgment can be extremely difficult. So always take these things into mind before kicking off litigation or deciding you're going to take things all the way. We're obviously here to assist with any and all disputes, large and small, and the sooner we're involved, the better. So I'm going to turn it back over now to Sean and Neil.
Thanks, Tim. And my favorite topic, how are we going to work with this new landscape and establish a federal and state legal framework for cannabis and ensure that there's still a pathway for these hemp products. And there's been a lot of productive conversations amongst stakeholders around what does sensible federal cannabinoid regulation look like, as Neil pointed to earlier. Notably, this is the first time we have any form of, finished product legal cannabis regulation in federal law. So it's really, a canvas we have an opportunity to build on and change. And how do we do that? So the industry is very focused on replacing the ban, with urgency, given we have this 1 year clock, and the longer we don't have a solution, the more at risk the industry is. So there's an immediate opportunity in the January CR, and then there's additional vehicles ahead, including the Farm Bill in 2026, broader regulatory bills that are in play by Senator Wyden, Representatives Griffiths, bills like the RAMP and the States Act that would establish or legalize cannabis federally where it's legal under state law. And, I think folks are uniting around working towards those long-term solutions and, focusing on, the immediate fix that we need for survival. I think many of us saw, efforts like Nancy Mesa's circulated bill to strike the language being introduced yesterday. So we're happy to talk offline about various efforts and where the industry is coming together. And there's so much education and lobbying and unifying the marijuana and hemp and alcohol stakeholders that can happen here, and that's already happening to really advance reform. But know that it is very hard to change federal law. It's very hard to change federal law with respect to cannabis. But we certainly have a lot of opportunity. And Neil, please add anything I'm missing there. There's a lot going on federally.
Yeah, there certainly is. And I'd like to also just kind of remind everybody that there are a lot of kind of aligned interests with states and state legislatures and state regulators. So it's a good opportunity to work with your locally elected officials, as well as your regulatory body, in your state that oversees hemp, to come up with and brainstorm for solutions. Because at the end of the day, the states will have primary control over, certainly retail sale of these products. So having alignment with those stakeholders is just as critical, in my opinion, as having good relationships in alignment with federal legislatures. And I think with that, we'll turn it back over to Brian to close us out.
Thanks, Gia. And I don't know if we have a map to pull up, but this has been a great conversation. To just the final piece in terms of how to make a difference in this next year is there's been a lot of chatter, not only on our phones this week, but in the chat function here about, well, the feds haven't come after regulated cannabis and they've been around for 20 years or what have you. And, true, there's been certain guidelines followed there. However, what they've had is very strong state regulated programs. Right. And as you can see from this map, there are not that many states that have super strong state regulated programs. And to Neil's point earlier, 27 of these states will lapse. Their state program will lapse if they don't take action in a year. Right. Like if there's literal state, needs to take action to prevent the federal government's Controlled Substances Act from, washing out their state program. So there's a lot of work to be done at the state level. Fortunately, we're plugged into a number of states, including Colorado and Massachusetts and other places that are really trying to, pass these creme de la creme hemp laws that will allow for, 10 milligram drinks or what have you. And I believe that, that's the best protection against the feds in some ways, saying, hey, we've got it. The same way we had it with medical cannabis, the same way we have it with adult use cannabis. We now have very robust, thoughtful regulations about adult consumption of hemp-derived products. And here's what they are. And I think that will likely keep the federal government from interfering. How does that deal with interstate trade and so forth? I guess we're kind of right in the playbook. I do think it's worth, in Colorado, we have an effort going to try to allow for potentially, out of state compliant hemp products that meet certain standards to come into Colorado's state. Will that be enough to keep the feds off our back with this, interstate interest of theirs? Perhaps, we don't know. But these are the kind of battles we'll be taking part in. So about 1,000 people RSVP'd for this Zoom. I think we broke the Zoom, and so a number of people could not get in. We will send a video copy of this to all of your colleagues as well as every attendee, and we're here to answer any questions moving forward. So I really want to thank my colleagues. This is an exciting time. Together, I think we can really make great progress. And my final thing is, if you want to learn more, we have a pretty thoughtful blog here. You can take a picture of that with your phone and keep in touch. So we really appreciate your time. We'll leave this up for a minute or two. And again, we'll send around a video recording of this, and we are very eager to chat offline about your business needs, about your policy needs, about federal policy, state policy, because together we can make it through this. So really appreciate everyone's time.